Simpson County Jail, we're on Central Time here, but we'll go ahead and take you. If somebody needs to turn that microphone on there, okay? Simpson County Jail. Y'all are on Central Time too, I know, but yeah, I thought we were on Eastern Time. Commonwealth of Kentucky versus Brandon Hall, 22 CR 0044. Are you Brandon Hall?
Yes, sir.
Okay, we're here in your case. Were you born in 1982?
Yes, sir.
Last four digits, social security number 3773.
Yes, sir.
Okay, what do we have here, Mr. Stockton?
Felony, please.
Motion, sir, has been made that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 21 CR 00100?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? You feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yeah. Yes,
You
sir.
have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, and have process issues to compel their attendance. You have a right to appeal this matter to higher court if you lose, and right to file the Commonwealth to beyond reason about that you're guilty of charges. And you understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting any recommendation, I will have a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea. Mr. Stockton, what is the
Yes.
Commonwealth's recommendation?
Mr. Hall will plead guilty to 2 counts of wanton endangerment first degree, receive a sentence of 2 years on each charge to run concurrently for a total of 2 years to serve. The Commonwealth will oppose probation. This sentence shall run consecutively with Clinton Circuit Court Case number 21 CR 123 and Cumberland Circuit Court Case number 21 CR 157. The defendant shall pay court costs at the discretion of the court.
Is that
And
what
I
you,
will tell the court that'll make a total of a 10-year sentence.
is that what you agree to, sir?
Yes, sir.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, sir.
Okay, are you satisfied with your attorney's representation?
Yes, sir.
One of your constitutional rights have explained to you, is it still your desire to enter the plea to the charges and allow the court to fix your punishment?
Yes, sir.
Now, do you understand by entering the plea, any future convictions of felonies could be enhanced under the persistent felony offender law?
Yes, sir.
Okay, now, there's a document here purports to have your signature on it. I can't hold it up here. You have to hold that up to the camera back there, the document with his signature on it. He handed it to me. Hold that up, Mr. Commonwealth Attorney, will you, to the camera? Is that your signature on there, sir?
Yes, sir.
Yeah, I'll accept the plea agreement. Is he a state prisoner?
He is, and he would wish to waive sentencing at the court.
Does the Commonwealth have any problem with waiving the pre-sentence investigation report and imposing a sentence? Mr. Stockton? Do you have any problem? He is a state prisoner with waiving the pre-sentence investigation.
No.
Yeah, I'll waive the pre-sentence investigation report, enter the judgment. Okay, I guess that takes care of Simpson County. We probably have no one else. Thank you for cooperation. Justin Gibson. Justin Gibson. Supposed to be here. Does anybody know where Justin Gibson is?
Well, I know it's in Wisconsin, so. I will show him in test.
Issue a bench warrant. Tammy Gibson. Tammy Gibson. Yeah. And back to Mr. Foster for a second, considering the length of his, excuse me. I'm gonna, considering the length of the sentence. Excuse me, I got a line there. It's Brandon Hall. Considering the length of the sentence, I'm gonna waive the court conference. We got 10 years. Thank you, Judge. This is Tammy Gibson, correct? Yes. Born in 1971, last four digits, social security number 5619.
Yes.
You're here today on 22 CR 0072 for pre-trial conference. What do we have?
Judge, I've told Mr. Stockton, we still have an investigation ongoing. I believe that there are clear cut documents out there, some of them government agency documents, which will conclusively prove that my client is actually innocent of these charges. We are still in the process of gathering those.
What do you want to do, Mr. Stockton?
We'll put out one more pre-trial.
Okay, this be here April 7th for negotiation. And April the 13th for your next court appearance. Both of those are conditions of your bond. You understand that?
7th and 13th
7th
of April.
April the 7th at 1 o'clock.
Nobody said that, but April 7th, April 13th.
Okay.
Okay.
Thank you. Haley Harbor. Commonwealth of Kentucky versus Haley Harbor, 22 CR 0034. You Haley Harbor. You're also here on 22 CR 0039. You born in 2000.
Yes,
Last four digits, social security number 6213.
yes.
Mr. Stockton, what do you have to say in this case?
Your Honor, Ms. Harper's co-defendant, Mr. Carter, I have an appointment to do the witness in this case, so either we can put up one more month of the trial.
Let's put it off one more month. They have a negotiation day on April the 7th at 1 o'clock, and the next court appearance is April the 13th.
Your Honor, let me note for the record, at this point in time, I've got a Wayne Circuit trial on the 13th. However, I've been told there were 6 cases to try that day, and there's just, they have such a backlog up there, they're really trying to address it. I may be here and I may not be. I'll be letting Mr. Stockton know in advance in the court trial.
That's fine, Your Honor. If he does have a trial, we'll do the over the past. Or get some dates.
Clifford Kennedy. Clifford Kennedy.
He's in the, I don't see it on bond.
Yeah, it's supposed to be. What about Clifford Kennedy? Anybody pre-trial know anything about Clifford Kennedy? Yeah, on bond.
Mr. Thompson represents.
Let's see if he was noticed to be here today. They can't hear you.
Oh, I'm sorry. The last time we received is a 3-1 continue in the case of John Day, other than the Commonwealth Hall.
Yeah. I think it's one of your-
He posted on January 16th.
Do a bench warrant. And a motion to show cause why this attorney should not be held in contempt for not being here today. Have the attorney come back on April 13th. Justin Lynch. Commonwealth versus Justin Lynch, 22 CR 0004. Are you Justin Lynch? Born in 1975. Last four digits of your social security number 7597. David Cross, your attorney. See where Mr. Cross is. What does the Commonwealth have to say for Mr. Lynch?
Supposed to be in the pretrial verdict.
We are, Your Honor, and paperwork is in limbo somewhere in my office. We didn't, it's been sent, not received, so we'll have paperwork in a few minutes to complete.
Yeah, come back to you.
Yeah, take this.
Richard Mason,
She's bringing, she's resending it, it's on the way.
Richard Mason. Commonwealth versus Richard Mason, 23 CR 0007. Are you Richard Mason, sir?
Yes, Your Honor.
You were born in 1983.
Yes, Your Honor.
Last four digits, your social security number 5063.
Yes.
What does the Commonwealth have to say about Mr. Mason?
I guess there's new discovery since the re-indictment, so we probably need one pretrial and trial.
April the 7th at 1 o'clock, the negotiation, and April 13th, your next court date, okay?
Thank you, Judge.
Wesley McGall. Commonwealth Kentucky versus Wesley McGall, 23 CR 0002. Are you Wesley McGall? Are you Wesley McGall?
Yes, sir.
Born in 1970.
Yes,
Last four digits, your social security number 8985.
yes, sir.
What does the Commonwealth have to say about
Your Honor,
this?
Mr. McDowell entered a plea and, determined in the last motion today. And once his final sentence in that case, as part of that plea, this case will be dismissed.
So you want to, what is our next rule there? Republican?
16th.
16th, so you want to have a submitted agreed order.
I'll just submit an order.
So he's gonna have to come back here if that sentence is entered over there, sentenced over there, then you can do an agreed order dismissing this case. Okay,
Thank you, Your Honor.
if not, you'll be back here on April the 13th. Okay. Cody Parrish. Commonwealth versus Cody Perigin, 22 CR 0035 and 22 CR 0038. Are you Cody Perigin?
Yes, sir.
What does the Commonwealth have to say about this?
He was Miss Harbor's coach, and it same for guys in 1 month before the result of the problem.
That would be April the 7th at 1 o'clock and April the 13th. Both of those are conditions of your bond. You understand that?
Can you write that down for me, please?
I get it.
April the 7th at 1 o'clock and April the 13th at 9 a.m.
Thank you.
Kathy Phillips. Commonwealth of Kentucky versus Kathy Phillips, 23 CR 0003. Are you Kathy Phillips?
Yes, sir.
You're born in 1979.
Yes, sir.
Last four digits, social security number 6652. What does the Commonwealth have for Ms. Phillips? What does the Commonwealth have for Ms. Phillips?
I don't know, for some reason, Mr. Shepherd and I didn't discuss this case. Pre-trial, is she here?
And right there.
Yeah, for some reason, we didn't discuss that.
This is one where me or my successor council needs to file a motion on this one, and hopefully that can be done for the April date. If we can set it for that date,
You want to have a negotiation, what kind of motion you got?
suppression motion.
Okay, so there's no reason to have a conference.
Until that is settled, no, I don't think
Okay,
so.
we'll have a citizen suppression motion at the end of the docket on April 13th. Okay? Under same conditions of your bond. If you have a new counsel, they will contact you
Okay.
and give you the contact information, okay?
Okay.
Nancy Raines.
Thank you.
Commonwealth versus Nancy Raines. 22 CR 0067. Are you Nancy Raines?
Yes.
Born 2001. Last four digits, social security number 0300. What does the Commonwealth have for Ms. Raines?
Your Honor, Ms. Raines is tied up in one of the 6 cases involving Jeremy August. And I was depending on setting Mr. Roberts trial date because he played down his counsel telling him he wants to enter the court. So as soon as I can deal with Mr. Alders and Mr. Karen, then I'll give it. That's all. right.
On negotiation day on April the 7th and the next court date. Ms. Raines, could you pass a drug test today?
Okay.
You want to take one?
Well, I'm not gonna lie, now I probably could,
Do what?
I probably could.
I know you can. Yeah. What do you take?
No,
Meth,
no,
marijuana?
yeah, that's
Is
it.
she gonna be honest with you? I'm gonna let her go.
Well, I think that's all.
I am being honest.
Yeah,
I know. I mean, you act like you're gonna, like I was fixing to do something.
she's
I'm
Johnny
not.
on the spot here.
Yeah, well, let me tell you something. You're out on bond. Stuff is illegal. Okay. You can't be self-medicating with marijuana or other things. I have a feeling, I'm not gonna call you, say you're not telling the truth. I have a feeling there might be something else involved from the look of it. Okay, but I'm gonna take your word for it, okay? Because you've been honest. But you need to clean yourself up before you come back up here. You understand? I don't want you, because you're out on bond and you can't be doing that. What day you need her back, Mr. Stockton?
Have her back at 7, we may well be able to. say-
Okay, I'll have you back 1 o'clock on the 7th. And the next time on the 13th, and you just know that you might have to pee in a jar when you come back. You understand what I'm saying? You come back clean. Okay, thank you very much. Chad Scott.
He's not in custody. I've got him as absconding from probation.
Okay, there's a warrant out.
Yes, sir.
Noah Stockton. Noah Stockton,
Ask for a warrant.
warrant. Kyle Trader. Kyle Trader.
I was unsure why that case was on the docket.
You look at that, please.
Because the plea, everything's been yeah. I didn't know if it was courthouse or why. It was on the docket.
No, we don't put them on the regular docket like that. Courthouse, we just have them.
Maybe it's the restitution. I don't know if it's paid that.
There's no one to say the time.
Why didn't you put that on the docket? You what? I know, but you know why we put it on the docket. Well, Mr. Stockton, I'll let you take a look at Kyle Traylor. If you want to redoct it for some reason, you can, okay? Curtis Tuck, active warrant. Has warrant been served on Mr. Tuck yet? Has he been processed? Okay. Are you Curtis Tuck?
Yes, sir.
This is 23 CR 00010. Were you born in 1985?
Yes, sir.
Last 4 digits, social security number 5102.
Yes, sir.
Is this a child support case, Mr. Stockton?
It's-
What kind of case is this? Curtis Tuck.
It's a alleged sex offense, John.
Wait, is it failure to register or
I
alleged?
was attempting to cure a minor by electronic means has been indicted.
Who are you represented by an attorney?
No, sir.
Can you afford an attorney? I mean, why don't you have an attorney here today?
We're just waiting, I guess, to see. I'm not sure.
Yeah, well, I'm gonna appoint the public advocate just for the purpose of arraignment today. And when you come back for negotiation, you need to have an attorney with you. And when you come back for your next court appearance, you need to have an attorney with you.
Yes, sir.
And if you cannot afford one right now is the time to tell me, and I'll have a pretrial to do an affidavit for you to see if you can afford one. Okay, you have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you with unlawful use of electronic means originating or received within a commonwealth to induce a minor to engage in sexual or other prohibited activities and prohibition of multiple convictions arising of a single course of action, solicitation as evidence of intent, 2 counts. Now, where do you live, sir?
Auburn.
Okay. Okay, you acknowledge the identity of Mr. Tuck, in receipt of the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Yes, sir.
Okay, Mr. Tuck, I'm gonna sign a reciprocal discovery order, and when you get an attorney, the attorney will need to contact the Commonwealth Attorney's Office to get the evidence involved in it. You're to be back here with an attorney on April the 7th at 1 o'clock and back here on April the 13th at 9 o'clock. Both of those are conditions of your bond. Now, what kind of restrictions do we have on the bond?
Your name and parents, you guys want to contact us.
Okay, you understand that?
Yes, sir.
Okay. Okay, you are relieved from representation. You'll be back here on the 7th with an attorney. And on the 13th, and I'd suggest you make provisions now. Do you have a job, you have assets, you have that sort of thing? Well, then you can probably find an attorney, and there's several of them around, okay? So you get somebody as soon as you can. Okay, thank you very much. Jameson Wallace.
Your Honor, he's incarcerated for arraignment.
Where is he incarcerated?
Lincoln County.
So we'll just move him to the jail docket. Joseph Wallace.
Your Honor, we have this one resolved, but we're again waiting on some paperwork that.
Mr. Wallace, have a seat back here. We'll come back. I'll come back. We'll tie a web.
That case should have been dismissed, Your Honor. I think we can ignore the G. Yeah. I'll check. It should be dismissed. He's paid this.
There's an arraignment for today.
Well, what happened was there was a preceding case. He owed restitution. He hadn't paid it, so I did an additional indictment in order to prepare for trial. He paid it, so both cases should be dismissed.
Okay. So in order. Okay, well, that concludes the call of the docket. Now we have some cases that have to have paperwork done. So what we're going to do now, we're not on. Simpson County was 10, so Wayne County's coming next at 10 o'clock. So we'll off the record for 30 minutes. Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything, right to speak, trial, the jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose, and right to file a comment if on a reasonable doubt that you're guilty of charge against you. You understand by entering guilty plea that you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation that I may apply in the range of sentence provided by law. After reviewing a pre-sentence investigation report, I've done my probation and parole. If I determine that I'm going to impose a harsher sentence, you have a right to withdraw your plea. You understand that? Y'all will step to your left here, all on your left. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to receiving stolen property over $1,000, the defendant shall receive a sentence of 1 year to serve. Probation is to be supervised. The defendant shall pay court costs at the discretion of the court.
I think it's just one to serve. No probation.
Yeah, it needs to be interlineated there. An initial that needs to be changed and let your mind something.
Yeah, that last line should have been marked out.
Mark it out. You initial it, the counsel and the defendant initial.
We have the original.
I don't have the original.
It should have been filed.
One year to serve.
That's great.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty of your own free will because you did commit the acts as an indictment as amended, knowing your constitutional rights? Knowing your constitutional rights, is it still your desire to give up those rights in a plea and out of court to fix your punishment? Just let him in the middle and you get on this side over here, okay? He's the star to show you. You understand that you're, that by entering a guilty plea, any future convictions can be enhanced as far as the penalty. You've already identified your signature on there. I'll accept the agreement order. Pre-sentence investigation report could be done by probation control. Mr. Stockton, Mr. Cross, we'll do it. Let's move back away from it just a second. This is a year to serve. So I'm gonna take him into custody here today, and we'll have the sentencing on April 13th. Okay, you're in the custody of jail. Who do we have left?
We've got Justin Lynch, we're ready on, Your Honor. It's a
Okay.
diversion.
Commonwealth versus Justin Lynch. Commonwealth versus Justin Lynch. 22 CR 004. Mr. Lynch, you previously identified yourself, I believe. I understand that you wish to enter a plea today. Is that correct? Yes, sir. Are you currently under the influence of drugs or alcohol? No, sir. Is this plea freely and voluntarily given? Yes, sir. Are you the same person named in indictment number 22 CR 004? Is your judgment impaired today? Have you discussed this matter with your attorney? You feel like you're fully informed about your case? Yes, sir. You understand that you do not have to enter a guilty plea today. You have certain rights in the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter at higher court if you lose, and the right to file a Commonwealth prove beyond a reasonable doubt that you are guilty of charges against you. Understand that by entering guilty plea today, that you give up those charges. Now, I may get those rights. I may consider Commonwealth's recommendation, but I may apply in range sentence provided by law. In the event that I don't accept the recommendation and say that I'm going to impose a harsher sentence, you have the right to withdraw your plea. You understand that? Yes, sir. Have you previously had a pretrial diversion in the last 5 years? No, sir. Do you have any felony convictions in the last 10 years? No, sir. Okay, are you currently on probation or pretrial diversion of any kind in any jurisdiction?
No, sir.
You understand that if you fully complete the diversion, the charge will be dismissed pretrial diversion. You understand that? If you do not complete the diversion, you will be brought back before the court and the court will schedule a sentencing hearing.
Yes, sir.
And then you will be a convicted felon and that could be used against you in the future. You understand that?
Yes, sir.
July 2015.
That's not within the last 5 years. Right?
Yes.
You know, I was worried about that part of the law is, and I can't tell if it's the diversion, the day it was entered within 5 years. Or the period of diversion. And I looked at the statute and I couldn't tell. I don't think it explains. Really, so I guess it's up to our discretion.
It was in 2015.
Yeah, that's what I'm saying. But for instance, he was diverted in 2015 and it was for 5 years. And that might be 2020, so that precluding from getting the diversion. And I looked at the statute and I didn't think it was clear, so I thought it was up to our discretion.
I believe it was 3 years.
Yeah, I'm just giving it hypothetical, so
I think you're right. I think we've run up on this before that
there's a law on it, I couldn't find.
I think you could construe it the way you want to.
Look at the statute. I want to take a look at the statute. Just in that book, right there. Well, that's 2017 book.
The statute says no person shall be eligible to be put on a burden more than once in the following.
I'm just saying it starts. Given $3. Okay. Says no person shall be eligible more than once in a 5-year period. So I think that was when he was given the pretrial evaluation that I'm gonna say. Are you pleading guilty because you committed the acts charged in the indictment as amended? Okay, you plead guilty of your own free will. What is the charge that he ultimately is pleading to, Mr. Stockton? Move to your left. Move to your left.
Oh, to the recommendation. The charges of possession of a controlled substance, first degree.
Okay, and you're pleading guilty because you did commit the act of the indictment as amended. Is that correct? You know, your constitutional rights explained to you that still your desire to give up those rights and plead guilty to charges while the court to fix your punishment. Is that your signature on the agreement?
Yes, sir.
Well, I'll accept the diversion agreement. I'll sign it here in a minute. You'll still need to meet with probation and parole and give them certain information. And you realize if you violate the terms of this agreement, you'll be brought back in front of the court. A pre-sentence investigation report will be requested to be a convicted felon again.
Yes, sir.
That could be used against you in the future. You understand that?
Yes.
Okay. Go ahead and meet with the probation and parole officer. She expects to have an ankle monitor. Is that part of the agreement, an ankle monitor?
Yes, Your Honor.
She got one of them.
We'll have to make arrangements.
You what?
You'll have to make arrangements with Mr.
Well, he can't leave until he has one.
Larry.
Sir, you're gonna have to make arrangements to get an ankle monitor put on. I'll allow you to do that by the close of business today. You have an ankle, they'll tell you that, and you'll need to do it by close of business. If you don't have one, I'll report to the Clinton County Jail. Okay, who else do we have unfinished here? My list is obliterated now.
Wesley Rains.
Yeah, I'd say that it's going to. It's been done.
Helen Catron,
That's, I'm signing the paperwork now, and I'm gonna give it to Mr. Carroll, so I'm gonna go
Okay. where is Mr. Carroll?
He's in the jury room, me and Mr. Hunley are having a discussion about the current state of law.
Who was that? Brandon Clark. Mr. Clark is an add-on, Mr. Stockton. Commonwealth versus Brandon Clark. I believe he made a bond, is that correct? This is a child support case. Yeah, the bond was on the indictment, he was extradited. So they brought him back to Kentucky and the bond that was on the indictment, they let him bond out.
What kind of bond you post?
4,500 or something like that.
That's bond?
30, yeah, cash bond.
Okay.
But what are the arrears now?
I think it's more than that. I think it's not.
Are you represented by an attorney?
No, sir.
Did you have an attorney early on?
No, sir.
He had never been arraigned.
We didn't bring the file, but he currently owes.
He never had been arraigned, so I'm gonna ask public advocacy to step in for the purpose of arraignment. The grand jury of Clinton County has returned an indictment charging with flagrant non-support. Are you Brandon Clark?
Yes,
Born in 1991, last four digits, social security number 8017.
yes, Your Honor.
Okay, this is the public defender here. He's going to represent you just for this purpose. You acknowledge the identity of this individual, receive the indictment, waive formal reading, arraignment, enter plea not guilty, reserving all pretrial motions. Now, Mr. Stockton, we had to extradite this gentleman. Now he's the amount on the indictment is $3,000 something dollars, and he's paid that in bond.
Yeah, he's, well, he got those 97 things now.
Yeah, but he's not indicted for that.
Well, now the 2,000, I've never had that come up. I'm not go back to something.
Well, that's what I'm telling you.
It's routine happens because they're a little more. Before they go in, punch right in and see the house.
Now,
He's, he signed a waiver of extradition.
not yet. We're fixing to get there. I'm gonna ask you to sign a waiver of extradition. Now, do you have rabbit blood in you, or are you gonna come back up here?
I can come back up here, Your Honor.
We had one.
He signed one to get back. He's already signed one. Okay, what do you want his bond to be?
Well, it's 30. He's hoping that much. I'll be satisfied.
Okay.
But I don't want to break up.
You come back here for negotiations on April the 7th at 1 o'clock with an attorney.
Okay. Yes,
Okay, and then you be back here on April the 13th is your next court date. If you can reach some agreement with Mr. Stockton and make yourself current, he might very well agree to dismiss the indictment. You understand what I'm saying?
well, yes, sir. I do have a job and I was wondering if there was a way I could.
Well, you'll have to discuss that with your attorney and Mr. Stockton. And, you know, they might do a wage assignment or something
That's
like
right.
that. Yeah. So if you come up on the 7th at 1 o'clock for negotiations, y'all reach an agreement. I could very well say that you don't have to come back on the 13th. If you don't reach an agreement on the 7th, then you have to come back on the 13th. You understand what I'm saying?
Yes, sir.
And y'all have business cards anymore? Do they make those?
I've got something I never carry.
Yeah.
Yeah, I don't think I can like afford a dream.
Go over here and get an interview right over here by the pretrial, and I'll see if I can make the appointment permanent. Go in and back. I think I'm gonna. You can go back to chambers if you want to back there. Okay, do you have anybody else on this docket? Got one doing the paperwork on it, Ms. Catherine, is that right? Is it-
Cross has got this range. He's in jail, he's in prison, so we're about to take him to jail.
Where is Mr. Cross? Has he gone over that with her yet?
No, it's Mr. Carroll. I'll be.
Look at Mr. Carroll. Have you gone over this with this lady?
I have not yet, Judge. I just received it. Thank you for your this. Big sign.
Let's go off the record.
If they get you that call.
Carroll's not on the back up. Wayne County, are you on the air? Wayne County.
Yes, sir.
If we could have, you want to do males or females or doesn't matter?
Let's do the mail first.
Okay, Commonwealth versus Benjamin Claywell. Commonwealth versus Benjamin Claywell. Are you Benjamin Claywell?
Yes, sir.
You were born in 1986. Last four digits, your social security number 2415.
Yes, sir.
I hear Mr. Claywell's name called.
He's on, we're here for a pretrial conference. So yeah.
Judge, the last time we were here, I talked about some experts and unfortunately, the expert we intended to use has basically retired. Or at least focusing on one case where he's not taking cases. And we are in pursuit of another expert in that field as well as an
There's a
expert
charge in this.
murder.
Vehicular homicide.
And we are also in the expert, I think there's some medical, there's going to be some controversy as far as the medical information and cause of death. And I think we're going to need a medical examiner type expert as well. And we are in
Somebody's gonna be making ex parte motion.
Right. And I gotta obtain one and get the rates before I can come to you with that. And that's kind of the holdup. We have a meeting scheduled with an expert next week.
May the 11th. And you need to have any, whoever channel in this case, we'll have to have need to ex parte motions filed with me so we can try to get the same meeting.
Okay, thank you, Judge.
Okay, Brandy Beatty. Commonwealth versus Brandy Beatty, 21 CR 0018. Are you Brandy Beatty?
Yes, sir.
Were you born in 1985?
Yes, sir.
Last four digits, social security number 9531.
Yes, sir.
You're on a probation revocation. What does the Commonwealth have to say?
Your Honor, this is a motion to revoke shock probation. It's on a possession case, 3 years. I can go through it or I can have Ms. Sexton testify. I don't know where we are on this.
Just read what they are real quickly.
Well, in March 24th of last year, I agreed to shock probator and she got a 60 days home incarceration and was supposed to complete SAP. In August, she was positive for meth, Xanax, THC, and Suboxone. November 29th, she was positive for meth and marijuana. She was supposed to go to ARC through probation parole. She ended up going to Journey Pure instead, a long-term rehab. She checked in February the 16th of this year. She checked herself out February the 20th. She was there 4 days. Then when she reported on February 21st, she was positive for meth, Suboxone, benzos, and marijuana.
Mr. Stefan, you all want to stipulate the violation and argue for sanction?
That's our position, and in the report that was submitted by the Probation Pro and the Commonwealth, Probation Pro does have a bed for her. And I think she's in a better place mentally with her mental health now and with her overall situation to attend and complete a long-term treatment than she was previously. I think she had some extensive conversation with probation and pro about those issues. So we would ask the court to allow her to serve some period of time she has been doing, and then attend this bed date that probation and pro already has lined up for her.
Mr. Stockton, what do you want to say?
Well, Your Honor, I've done all I can to help Miss Beatty. You know, I like her father. I care about everybody that comes in front of me in court, but she's literally going to kill herself because of her drug use. I've put her in prison before on a previous case. I put her in drug court. Nothing's worked. And until she proves to me she can do something, I'm going to ask that she be incarcerated.
And even though probation pro does have a bed, she would be willing to do drug court again. That's been 8 years since she was in that. And hopefully she's, would be more successful this time around if given the opportunity.
Well, I'll just say she's been given opportunity after opportunity, and she's never availed herself of it. At some point in time, there has to be a consequence for her actions.
Well, I'm gonna revoke her probation and hope that she gets treatment. With all the way it is, she will not be in there very long.
No.
She's probably a 15%er.
She will. She'll be out in no time, and then she can do what she wants, and it's up to her.
Well, she'll
whether
be under the supervision of the parole board and not us. And I don't think there's anything else we can do. Okay, good luck to you. Misty Duval. Misty Duval. Are you Misty Duval?
Yes, sir.
You're before the court today on the other hearing, it says. What does the Commonwealth have to say?
Your Honor, this is also a motion to revoke. Miss Duval was placed in drug court in August of 2022. No, I'm sorry. She was placed into drug court based on a probation violation. Then she absconded drug court August 8th, 2022. She has a 5-year sentence on tampering with physical evidence and possession of controlled substance first.
When did they capture her?
Just recently, last 45 days, I guess.
You want to stipulate on Miss Duval?
Yes, Judge, we don't dispute that she was terminated from drug court. I would like the court to consider a sanction, an alternative sentence, or a treatment option for her as well.
Okay, we take very seriously people who abscond from the drug court and are fugitives that are outside the supervision of the court. So I'm going to revoke her. And this wasn't a pretrial diversion, it was a felony plea, right?
Yes.
I'll revoke her and hope that she can get some assistance by the Department of Corrections. Angela Riddle is next. Commonwealth versus Angela Riddle, 20 CR 0058. Are you Angela Riddle?
Yes, sir.
This is, are you born in 1980?
Yes,
Last 4 digits, social security number 4728.
yes,
This
sir.
says it's a shock probation revocation, Mr. Stockton.
Yes, Miss Riddle was shock probated, Your Honor, and as part of the conditions of her shock probation, she was to enroll in complete drug court, and she was terminated from drug court because she absconded.
You want to stipulate, Mr. Sheffett, and make your argument first?
Yes, Judge, we would stipulate. I would ask the court to consider an alternative for Miss Riddle. She does have an 8-year sentence, so it would be, and she doesn't have a ton of time in on this, so it would be, she'd be looking at a pretty hefty stay before she could have a chance of being released. I would like the court to consider, if not today, maybe in a shock motion, some inpatient rehab possibilities. I think Ms. Riddle understands that she does need to help herself and take action and take responsibility and would like the court to give her one more opportunity.
Okay, I'm gonna revoke Ms. Riddle and if there's any other relief that's reaching out, we can bring it back to me again. I don't think she is since she's already been out on shock probation once. Okay, thank you very much.
Thank you.
Now, Mr. Brandon Clark, are you still here? Yeah, I'm gonna appoint public advocacy to you and I'm gonna make an assessment in the amount of $500 for you to pay Office of Public Advocacy.
Judge, I have his contact information. He has the court dates. Mr. Clark, or if one of the bailiffs could give you my card, if I didn't give you one already.
And you need to be here on April the 7th at 1 o'clock and you need to be bringing $500 with you to pay into the public defenders and then they'll negotiate the rest of your case, okay? Okay, be sure you come or I'll send the dog after you, okay? Now, who you have?
I have Helen Catton, Your Honor.
Helen Catherine, come around. Wait a second. Come around, Miss Catherine. Let her in the center, you get on her left, okay? Commonwealth Kentucky versus Helen Catherine. 22 CR 0077. Are you Helen Catherine?
Yes.
You born in 1951, last four digits, social security number 6709.
Yes, sir.
I understand that you wish to enter a plea today. Mr. Stockton, is this a felony plea?
It's a pretrial diversion, Miss.
Okay. A motion has been tendered. It says you wish to enter diversion. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? You're gonna have to speak up. Yeah, this is a voice activated microphone, so it doesn't pick up this or like that, okay? Are you the same person named in the indictment that I just reported?
Yeah.
Is your judgment impaired today in any way? Do you know what's going on?
Yes.
Okay, have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes.
Do you believe you're fully informed about your case?
Yes.
You have certain rights under the Kentucky and the United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have the right to speak trial with jury, your right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, call testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Understand by entering a guilty plea today, you give up those rights. You understand that? Now, may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. If I don't accept the recommendation, you'll have an opportunity to withdraw your plea and proceed to trial. Have you previously been diverted in the last 5 years? Or have you had any felonies in the past 10 years? Are you currently on probation?
No, sir.
Okay, now do you understand if you complete the diversion program, the case will be dismissed, pre-trial diverted, you get expunged. Do you understand that? You understand that if you do not successfully complete the diversion program or violate it, you'll be brought back and forth from the court and you would schedule sentencing.
Yes.
After a pre-sentence investigation report, then you would be a convicted felon that can be used against you in the future. Right? Step to your left, son. Miss Gordon Anderson, step to your left, man. Your left.
Upon a plea of guilty to trafficking in marijuana, defendant shall receive a sentence of 3 years, pretrial diverted for 5 years supervised. Defendant shall forfeit $7,390 to the Commonwealth of Kentucky and disperse in accordance with the laws of the Commonwealth and forfeiture orders submitted with this plea. The defendant shall pay a fine and a cost at the discretion of the court. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service until gainful employment is obtained. The defendant shall remain on active supervision until all court cost fines, restitution are paid in full, or until further orders of the probation and parole. The defendant agrees to have any and all evidence disposed of in a manner with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes.
What are the court costs?
155.
155, and you probably you need time to pay the 155? Let's pay it $30 a month, starting 30 days from today. Is this what you agreed to, this pretrial diversion?
Yes, sir.
Are you doing so because you did commit the acts as charged in the indictment as amended?
Yeah.
Know your constitutional rights, still you desire to give up those rights, and allow me to sign this order of pretrial diversion. Is that your signature on the document there?
Yes, sir.
I'll accept the agreement, enter the order, and you'll need to meet with the probation and parole officer, okay? Mr. Bailiff, you'll come over and get that and present it to the clerk. Okay, what else do we have on this morning docket live here? Okay, you need to meet with the probation and parole officer right over here. Okay. Okay, well, we'll go off there for 10 minutes and we'll be next going to the
They were on earlier.
Maybe the judge just wanted to break.
They were on like way.
Okay, let's go to the Clinton County Jail, please.
We talk about the Cook County politics.
Jameson Wallace. Jameson Wallace for the purpose of arraignment. Clinton County Jail.
Wallace.
Are you Jameson Wallace?
Yes, sir.
Were you born in 2003?
Yes, sir.
Last four digits, that's security number 1655.
Yes, sir.
You're here for the purpose of arraignment. Mr. Cross, you represent this individual.
We do, Your Honor.
You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with menacing possession of an open alcohol container, criminal trespass, assault in the 4th degree, and wanton endangerment in the 1st degree. Mr. Cross, you acknowledge the identity of your client, received the indictment, wait formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
Absolutely.
Okay, we'll come back here on April the 7th, and then for a negotiation day in April the 13th. Now, has there been some activity about Mr. Wallace here? Yeah, I received a call this morning. It says that there were charges placed against him last night involving a weapon. Is that right?
I believe that's Sidney Foster.
Okay, well, what's the story on this gentleman? Where's his bond?
I need to file.
And what was your evaluation of the situation? You what? What do you have to say, Mr. Stockton?
All I know is what's on the report. I know Mr. Wallace's father, and my understanding was they wanted him to go work for him, but I don't know what kind of bond is he under.
25,000 property bond?
25 cash, 50 property.
Let me see, is this his file here? What do you know about the case, Mr. Stockton?
Well, I know the victim alleged it was a dispute over custody of a child, and the victim alleged that Mr. Wallace had a gun and struck one of them on the hand with the gun, but the officer couldn't find any gun and when he arrested Mr. Wallace.
Your Honor, we did conduct a preliminary hearing and there was evidence of a brandishing of a firearm. There was initially a more serious assault charge. District Court found no probable cause on that because the witness said it was an accidental thing.
What do you have to say, Mr. Stockton? This firearm thing bothers me, brandishing a firearm when you're out menacing someone. Alcohol beverages with an underage person.
Yeah, I was initially really concerned with it for the preliminary, the part was this next to them. I read the officer report and the officer quote said Jamison Wallace supposedly had a weapon. I don't know. Officers in advance, there was no weapon recovered at the scene. You know, as long as you don't secure bond, no contact with the victim. You know, you don't have any previous record.
Are you working someplace, young man?
Yes, sir.
Where do you work?
Wally's Houseboat Repair.
Your Honor,
What?
Wally's Houseboat Repair.
Your Honor, his father is his employer and he's in the courtroom. If the court would like some specific information.
I don't need it.
Okay, what we ask, Your Honor, is they do travel all around the southeastern United States doing houseboat maintenance and repair. And if the court could lower that property bond somewhat, Dickie could make a property bond for him. The home monitoring, the incarcerations is going to be impractical by reason of the way they travel and such. And I don't think
Those monitors will reach anywhere.
well, no, they will, but
What I want to do is reduce it to a surety bond.
okay.
$25,000 surety bond his father can make.
That's good.
Then I want to put a curfew on him, except if he goes to work with his father.
That's good.
And because there's the allegation of the handgun, I want to keep the monitor on until our next court date, and I will consider taking the monitor off. Young man, you're not to be around any handguns, any guns of any kind, and you're to stay completely out of contact with the alleged victims. Okay?
Okay.
Thank you, Your Honor.
And sir, you can go make the bond. You can make the bond for him. You can sign the $25,000 surety, and he can go to work. Are you with him all the time when he works with you?
Yes, sir.
So you need to, I'm gonna let him go ahead and work. I can work whenever possible. And you can travel. All you gotta do is call the people that keep the ankle bracelet on him and tell him where you're gonna be and when you're gonna be back. And if you're staying all night,
We actually stay on.
okay, when you stay all week, he's to be with you at night. And as they kind of say over Monroe County, he's not to be out of gomming around. Okay.
Yes, sir.
Okay, thank you very much. See you on he'll be here on April the 7th for negotiation and April the 13th for the court hearing. Now we'll go to Jeremy Albertson.
Your Honor, we're still preparing the paperwork, should have it done shortly.
Okay, we'll come back to Jerry Albertson then. Let's go to David Carnder. David Carnder. Commonwealth versus David Carnder. Are you David Carnder?
Yes, sir.
Are you born in 1993?
Yes, sir.
Last four digits of your social security number is 0416.
Yes, sir.
You're here today on 22 CR 62, 63, 64, and 78. What does the Commonwealth have to say?
Well, I've made an offer in this case. I don't know if Mr. Sheffitz, if he's going to accept it or not.
Well, I'd like to see, I think the outcome of Mr. Albertson's case, as well as what his position may be regarding David's involvement or lack thereof in some of the cases, is worthy of another negotiation day and a pretrial.
You lost me somewhere here. What did you say about Mr. Albertson?
I guess in every one of David's cases, Jeremy is a co-defendant. And I think that plea, as well as what Mr. Albertson, if he has any statement as to David's involvement or lack thereof, could, I think, influence hopefully a plea agreement. And I don't know if the Commonwealth is part of Jeremy's plea may be to testify against David. I don't know at this point.
It is not.
So, Judge, I'm just asking. He's got 4 cases here. We know he's facing some potential time. I'm just asking. I do think it get wrapped up in April.
We're doing a negotiation day on April the 7th. The next court appearance is April 13th. And if there's not an agreement on April the 13th, we'll set a speedy trial date. Okay. Cody Chilton.
I need his file.
Cody Chilton. Commonwealth versus Cody Chilton, 17 CR 0055. Mr. Chilton, were you born in 1988?
Yes, sir.
Last 4 digits, social security number 0119. We're here
Sir.
on probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Chilton has a 10-year sentence on possession, fleeing, evading, burglary. Second, he had a DUI in Hardin County back of March of 2022. That case is still pending. Recently, he was picked up because he was charged with domestic assault in Pickett County, Tennessee on January 21st. I called yesterday to check on those charges, but I didn't realize the circuit clerk's office is closed on Tennessee on Wednesday in Pickett County, so I was unable to determine what's going on in that case.
Is that the only thing that you're holding him on, the domestic charge down there?
Well, that's the reason he'd been out working evidently and doing okay while I was waiting on the DUI, and then he gets the domestic case, and that's when he gets picked up and put in jail up here.
And then-
That's the only new violation.
What's probation have to say about this, Jim? Mr. Cross, what do you have to say? You represent Mr. Shelton.
Yes, Your Honor. Cody called me when he had the DUI. Mr. Stockton was made aware of it. He does have defense counsel up there. It's pending. Apparently, there's some defense to it, but regarding, it's not been disposed of. The Pickett County case, according to Cody, was a dispute with his mother, and that's disintegrating or already been dismissed, according to what Cody tells me. Cody's living in Hardin County, has an apartment in E-Town, is working and making good money. And my thoughts would be this is an appropriate sanction for him. He's been in nearly a month. And if he gets convicted on the DUI and Mr. Stockton wants to revisit it, that can happen, but he's got a good opportunity to go up there and work, and they're holding
Okay,
his
well,
job at his apartment.
I'm gonna allow somebody to make a $10,000 surety bond, clerk approved surety bond. And I want an ankle bracelet on him. Because of the allegation as far as driving is concerned, and Mr. Chilton, you shall not be driving a motor vehicle anywhere. If I find out you've been driving a motor vehicle, it won't be good. You understand what I'm saying? So where are you working at, Mr. Chilton?
For JCF Properties out of Elizabethtown.
Okay, so as soon as you get an ankle bracelet lined up for you, I'll let you out of jail. Somebody make a $2,000 surety bond for you for your appearance. And the next appearance here will be on April. Well, that might not be long. Well, let's try it on April 13th. And Mr. Cross, if they have not resolved those cases down in Tennessee, but then you could, by agreed order, we'll take it out another month.
Thank you, Your Honor. Cody, I'll call you here in a minute, okay?
All right, yeah, sure. My mother's.
Mr. Cross will call you in just a minute and make sure you have the details, okay?
Okay.
Okay, Cody Daly. Cody Daly. A lot of Cody's and Codys in there. Commonwealth versus Cody Daly. 23 CR 0006. Are you Cody Daly?
Yes.
Were you born in 2002?
Yes.
Last four digits, social security number 7105, correct?
Yes.
You're here today on a pre-trial conference, Office of Public Advocacy. Mr. Sheffield, what do you have to say on this case, Mr. Stockton?
We have a pretrial diversion for the court to consider.
Mr. Daly, a motion has been filed that says you wish to enter guilty. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
This plea freely and voluntarily given. Are you the same person named in indictment number 23 CR 0006?
Yes.
Okay, is your judgment impaired today? Do you know what's going on?
Yes.
Your judgment is not impaired, is that correct?
Yes, that's right.
Okay. Are you satisfied with the advice of your attorney?
Yes.
Have had plenty of time to review the evidence in your case. You feel like you're fully informed.
Yes, I am.
Before I can accept a plea, I need to know that you understand your rights under the Kentucky and United States Constitution. I'm going over those rights here. At the end of it, if you don't understand it, you can inquire, okay? You have the right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, about to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea today, you give up all those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply anything to the Senate to provide the law. I don't have to accept the recommendation. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and proceed to trial. Sir, have you been diverted previously in the last 5 years?
No,
You have any felony convictions in the last 10 years, or are you on probation?
no,
You understand, if you fully complete the diversion program, the charges will be dismissed and you can have it expunged from your record. Understand that?
yes,
However, if you don't complete successfully the diversion program, you come back in front of me, and if I avoid your diversion, you will have a sentencing, and you will be a convicted felon, and that can be used in the future. You understand that?
yes, sir.
Okay, Mr. Stockton, when you read what the agreement is, listen closely, sir.
Upon a plea of guilty of burglary, third degree, the defendant shall receive a sentence of 5 years, serve 180 days in jail. Balance pretrial diverted for 5 years, supervised. He'll pay $2,200 in restitution to the victim at the rate of $100 a month, beginning 30 days from his release, subject to a 5% courtesy fee. I did agree that if he's allowed to pick up trash, I'd give him 2 for 1 day jail credit. He currently served 39 days in jail. Pay fine and court costs at discretion of the court, obtain and maintain gainful employment once he's released.
Is that what you agreed to, sir?
Yes, it is.
Yeah,
Are you pleading guilty because you did commit the acts charged in the indictment? As
Yes.
amended. Okay, you know your constitutional rights that have explained to you. Is it still your desire to allow the court to fit? Now, were there some additional days to do Mr. Stockton to finish his day?
Yes, he likes about 140 days, Your Honor.
Okay. Is that your signature on the docket there? If you hold it up, Mr. Shepherd. I'll sign the agreement and diversion order, and the court costs involved are how much? What? $155 court costs. And you make your first payment of $30 on that 30 days after you're released from jail. That way it gives you a chance to catch up a little bit. You pay $30 every month until you pay the $155. Okay. Yeah, I'll sign the order today. Thank you very much. Matthew Denny will be next. Matthew Denny. Commonwealth versus Matthew Denny. Are you Matthew Denny?
Sir.
You born in 1986?
Yeah.
Last 4 digits, social security number 7916.
Yes, sir.
You're here today on 22 CR 0083 49 21 CR 56 55 20 CR 76 and 20 CR 47. First 2 charges are pretrial conference, and the latter charges are probation violation. What does the Commonwealth have to say, Mr. Stockton?
I've prepared felony plea paperwork, Your Honor, if we're ready to proceed.
We do have a plea, Your Honor.
Mr. Denny, a motion has been filed that says you wish to enter a plea today. Is that correct?
Yep, I guess so, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yeah.
Are
Yes,
you, are you the same person named in the string of criminal case indictments previously read?
Yes, sir.
Is your judgment impaired in any way today, sir?
No.
Have you had plenty of time to discuss this matter with your attorney and review the evidence? You feel like you're fully informed about your cases?
Yes, sir. Let's see, yesterday I had to kind of make a decision pretty quick, but I guess it ain't gonna matter, so let's just, I guess we'll proceed with this, whatever happens. Thank you, Your Honor.
Okay. You have certain rights in the Kentucky and United States Constitution. Before I can acceptably, I need to completely know that you understand those rights. You have the right not to testify against yourself. You have a right to speedy trial. You have a right to be represented by counsel, confront and cross-examine all witnesses, call, testify against you. The right to call witnesses and have process issued to compel their attendance. You have the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. You understand by entering a plea today, you give up those rights. Now, is he presently a state prisoner?
No,
So I'll have to order a pre-sentence investigation report to be done by probation and parole and bring you back on April 13th for sentencing. And Mr. Stockton, you want to go over what the recommendation is?
I will, Your Honor. Mr. Denny will enter a plea in indictment number 22 CR 83 to the charge of burglary 3rd degree. Yeah, and persistent felony offender 2nd degree, receive a sentence of 6 years to serve. The 6-year sentence shall run consecutively with Clinton indictment numbers 20 CR 47, 21 CR 55, 20 CR 76, and 21 CR 56. The defendant stipulates to the revocation of Clinton, those indictment numbers. The revocation orders will be submitted with these pleas. Under indictment 22 CR 83, once the defendant is released from incarceration or parole, he has $800.73 payable to the clerk's office restitution order. The Commonwealth opposes probation and shock probation on this case. And Commonwealth agrees to dismiss 22 CR 49 in its entirety upon at sentencing.
Going to dismiss it with prejudice in its entirety.
Yes, once he's sentenced, Your Honor.
Is that what you agreed to, sir?
Yes, sir.
Okay. You understand that after you enter this plea, you would be have an additional felony conviction that would enhance in the future. You understand that?
Yeah, yes, sir.
Okay, I will accept the plea, order pre-sentence investigation report to be done by probation parole, and bring you back here on April the 13th for sentencing. I'll signature up to this gentleman so he can acknowledge that's his signature on there, okay? That's your signature on there, sir?
Yes, sir.
Okay, we'll see you on that date. Thank you very much.
Thank you, Your Honor.
Randall Dickin.
Randall Dickin.
Yeah, I'm gonna take a brief pause here. You clear the jury. Just move over here somewhere. You bring the grand jury in.
All right.
Okay, everyone can be seated. Mr. Foreperson, have y'all completed your work? Have 9 or more of you agreed on the report that you have signed?
Now,
Okay, if you present it to the bailiff, you can have a seat and let me review. Ladies and gentlemen of the jury, I'll have either warrants or summons. If people are already in custody, sometimes we have summons done and set the bond on that and warrants. So primarily we protect the public and or ensure that they appear and don't get scarce, you know. So it's important that you keep the confidentiality of what happened in the grand jury room. The next date that you're to be here will be April the 13th, which will mean that the new year is already a third over. I'm not really used to writing 2021 yet. We're already a third over 2023. You know, my grandmother used to say the days are long and the years are short, and I'm starting to understand that more all the time. So thank you for your service. You may be excused unless you're called back into special session. You know, if there is some sort of a special need to come in, an insurrection or something like that, these days you can't ever tell, can you? So you're excused. Thank you for your service. I'll rise for the interview, please. Okay, let's go back to establish, I guess, the Clinton County Jail. We have an email, if we ever get called in. Well, it should. I mean, you got my address. Okay, I'm just. Okay, let's go to the jail. I leave at the top first. Get it on this list. Clinton County Jail. Okay, we have Randall Dickin. Randall, are you Randall Dickin?
Yes, sir.
You were born in 1966. You were born in 1966. You need to speak up.
Yes, sir.
Okay, the last four digits of social security number 6604.
Yes, sir.
Okay, we're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, he has a 3-year sentence on possession of controlled substance first degree. He was placed in the Clinton County Specialty Court, and he was terminated when he absconded about the end of October of 2022.
Okay, Mr. Shepard, is this one of your clients?
Yes, sir.
You stipulate to the revocation.
Yes, sir.
Okay, what do you have to say about the disposition?
Well, Judge, we don't dispute that he was terminated from drug court. I know that Mr. Dickin does have some health concerns, a hernia that he had surgery on that he hoped was going to relieve some issues, but in fact, perhaps it's created a greater issue, and that's flaring up on him in the worst kind of way right now. And I'd like the court to consider a sanction for him to allow him to get out and seek medical treatment.
Well, they have at the facility that he's going to, they have the capacity to make sure he receives free medical treatment on his arm. I hope your arm is better, Mr. Dickin. And I'm going to revoke the probation. Kevin Haddix. Kevin Haddix. On that last case, I'll consider that had been the shock probation, so he'd still be eligible to take a look at shock probation. Isn't that right, Mr. Shepard, at some juncture?
Yes, I'm not certain whether that was shock or not. I don't believe it was, though.
No, it's probation.
Probation, so you can take a look at his healthcare situation, or you and your successor. Commonwealth versus Kevin Haddix. 15 CR 00101. Are you Kevin Haddix?
Yes, sir.
You born in 1966?
Yes, sir.
Last four digits of social security number 3194. We're on
Yes.
15 CR 00101. It says probation revocation to end probation. What do you have to say, Mr. Stockton?
It's Mr. Shepard's motion. I filed a response on.
It says that beyond the period where probation was extended longer than legally possible. Is that right, Mr. Shepard?
Well, Judge, no, it's not an extension of probation. My issue is that the probation could not have been set for a 7-year period as it was in this case. Mr. Stockton does cite some cases regarding extension of probation, which I have no objection to that concept, but my problem is that you can only probate somebody for 5 years at the beginning. You cannot go beyond 5. Now, at a later point, can it be extended? Yes, under circumstances such as restitution is still owed, or maybe there's a probation violation issue and there's an agreement for a sanction and then be released back out on probation. Absolutely, but the 7-year period is not allowable. And that was set from the beginning, and that's the issue of my motion. And I understand that the Commonwealth believes that I'm attacking a judgment improperly here. I'm only stating that, he was put on probation 7 years ago, and we shouldn't be dealing with him at this point, 7 years from the time that he was sentenced.
Well, there's several issues going on. Number one, Mr. Haddix has not been determined competent yet. We had correspondence with KCPC yesterday. They're ready for his discovery, so they're ready to take him pretty soon. So I don't even think this motion's ripe until he's determined competent. Number two, even if Mr. Shepard is right, I couldn't find any case on point that said you couldn't do an initial plea longer than 5 years. But the Griffin case does say that once the defendant has the benefit of the bargain, that they're a stop from coming back and collaterally attacking the judgment. So that's my argument. I think this motion should be heard after he's determined competent or incompetent. And it's going to kind of be moot because he's going off probation in September anyway. We're talking about the difference between March and September.
Well, for what it's worth, I don't think, this is a legal issue that the defendant is not involved in terms of understanding or really participating in. So I don't think his competency is necessary for the court to make a ruling on this type of procedural.
Why was he given 7 years instead of 5 years probation at the time? I know he's been in here.
Well, he's had multiple cases over the years, Your Honor. And I think at the time, and I'm going by memory, he was only given a 2-year sentence. Mr. Haddix has suffered from mental health problems probably since onset of probably high school, probably when he's 15, 16 years age. So I knew that his probation would be a struggle, and that's the reason I recommended more than 5 years on this case.
So you're saying, Mr. Shepard, even by agreement, that the defendant can't be given more?
Well, I mean, I'm relying solely on the statute 533.020 subsection 4, where it explicitly states that it's a 5-year period, up to a 5-year period, and not beyond. It does
even
say
by the agreement of the defendant. If the defendant,
it does say such period with extensions thereof shall not exceed 5 years or the time necessary to complete restitution, whichever is longer. So you can say 5 years or until the restitution is paid, and then it can obviously go beyond 5, but that's not the situation here. I mean, the proper thing to do would have been to set it for 5 years, and then if there were issues, bring it before.
I understand that, but what I'm asking is a specific question. If you got down to a negotiation in a plea agreement and you said, well, we'll just give you 2 years instead of 3 years, but we want to probate it for 7 years instead of 5 years, you think that such an agreement is void ab initio?
Yeah, I don't, to me, of course, I would never negotiate such a plea because I know that to be something that's not allowable under the law.
Well, I'm asking you if it is allowed. The statute says 5 years, but you're saying even by an agreement, someone can't extend it beyond.
Right. And as an attorney, if I thought my client was, I'm not criticizing prior counsel, but 7 years for somebody who Mr. Stockton believes is going to struggle with probation. I don't know that was, I don't know about that ideal. Mr. Haddock seems like somebody you want on probation for a shorter period of time to give him a chance at success.
Well, I'll say this. When he's on probation, there's a better chance he'll take his medicine. When I said struggle with probation, I meant struggle with ordinary life and being able to comprehend things and being able to function somewhat a little bit in society and comport his conduct to where he's not out with a gun at static shooting up ceilings and things like that.
He's been on the docket since I've been judge for 12 years, almost consistently.
And it all goes back to the fact that our mental health system's broken. Mr. Haddock shouldn't be in the criminal justice system. His family should have help in the mental health system, and there's just nothing available for him.
We have some common ground with the Commonwealth on that statement, Judge.
Okay, well, if y'all have anything else that you'd like to, I'll give you both of you 10 days to give me any additional authority on it. It appears that we might have exceeded what we can do, unless Mr. Stockton, unless you can come up with some kind of authority.
Well, I think the court should read the very end of the Griffin case, and if you disagree with me and think that Griffin case doesn't control, then I'll go along with you. But I think you're a stop.
I don't have an opinion on it. Now, I don't disagree with you. I haven't had an opportunity to read it, and I've just given you an opportunity to get any other authority.
Okay, if I find anything else, I'll furnish it to both sides.
Okay, within 10 days, and then I'll issue an order on this, okay? Thank you. Cody Key. Commonwealth versus Cody Key.
Benefit of the bargain, you ought to do that.
That's what that Griffin case says.
Let me see this. Commonwealth versus Cody Key, 23 CR 005. We're here for a pretrial conference. What do you have to say, Mr. Stockton?
Well, we have a trial date set March the 22nd, and Mr. Cross says they're going to have a trial. I'll be filing a 404B notice here next week, and we probably need to have a hearing on that.
We will.
And this is the case where I tried to get the court to move it back one day, but we couldn't because of district court. I have a matter on Thursday, a personal matter that I'll be out of town. So we've got one day to try this case and have a 404B hearing unless we have it before.
There is a superseding indictment. Their indictment, Cody Lynn, is this Cody Lynn? Key?
That's from the previous case that Mr. Sheffield testified about at the bond hearing. And that'll be the basis of my 404B notice.
Okay, so he'll have to be served with the indictment on this case in the bond set.
Your Honor, may I speak?
Sure.
This gets into a real can of worms about this new indictment, and Mr. Stockton, I understand his 404B motion, but this is simply an allegation, and the indictment itself is such that I almost think, of course, what I want to do is get all these resolved, and I'd like to get a bond made for Mr. Key to where he can be out. But we
What
all
indictment? Are you talking about the indictment that was returned today?
Yes.
How do you know what was in the indictment?
I don't.
Okay,
I just know what you told me.
I'm just telling you there's an indictment.
Well, Mr. Stockton had said that when he and I negotiated, he said he might be seeking an indictment for the previous offense, and he just said that that's what it was. So I almost think that case needs to be dealt with first, and once that one's dealt with, and if it's a not guilty, then I don't think 404B would even apply. That's all going to come in the hearing. What do you think, Mr. Stockton?
Well, I don't even think you need a conviction to 404B notice. I think you just got to show motive, intent, or absence of mistake. And I think this part of the MO is what he uses in order to hit Mr. Sheffield.
Perhaps that's correct, but you see my point. If there's an acquittal on that, it certainly is a clear attack on the legitimacy of the prior occurrence.
Well, that's two different standards. Is what the 404B standard. And
What is this new charge? Y'all, I'm operating at a loss. Was there brass knuckles used in this new charge?
According to Mr. Sheffield, there was, yes.
Okay, and
And it's
that's,
not really brass knuckles. It's kind of like a homemade thing that goes around your hand, but it's metal. According to Mr. Sheffield. And that's not anything the court would know or anybody else would know. That's just from my interviews with Mr. Sheffield and some of the family members.
That occurred 2 or 3 years ago, I think, didn't it, Matt?
Well, it was right before Christmas of 21, about a week before. So I don't, I'll try these cases. I was going to plan on trying this one first. It's,
when is the case set for right now?
it's set for March the 22nd. My point is, I don't know that we can do everything on one day. I tried to get the case moved back a day, but there was district court the day before. So I don't know if we need to push this out a little bit, so we'll have time to deal with them or what, but I don't know that we can deal with this case just in one day on the 22nd, because I can't be here on the 23rd.
It has gotten more complicated, Your Honor, based on this.
I don't know if the court wants to consider a bond with home incarceration, or if you want to keep him in till we have a trial a week later or something. That's whatever the court wants to do.
Which I think of what I often refer to as a makeable bond would be appropriate, Your Honor. Courts figure if these people, they can make a bond, they can't make 100,000 cash.
Now, the 20th and 21st, we already have a trial set for that day, correct?
That's correct. Christopher Ayers, that should be one day. I have 2 witnesses.
And this
maybe
case
3.
here is set for the 22nd.
And I've
Yeah.
got Billy here.
Wait a
until
second, wait a
21st.
second.
No, I don't.
You have a conflict on the 21st,
Thought I did, but I don't. I've just got a couple of,
so we could take this case on the 21st and 22nd.
Yeah, that would be a help.
Other day by backing up a day, okay? So let's do that, so. Okay, we'll start this case on the 21st. And if the Ayers case was to go over to the morning of the 21st, we'll finish it out and then start this one up on that same day, okay? Now, you want to bring up the bond thing again?
well, Your Honor, I think I think Key family could make a property bond. It's hard for anybody to make $100,000 cash bond. And
Could you get behind the podium where I can hear you a little bit better?
sorry. I think something in the way of a $25,000 property bond with conditions, whatever the conditions the court wants to impose would be appropriate. He's got, this young man's got.
I don't have any problem with
I don't see any need of having a bond reduction now. We're gonna keep the same problem.
well, what I was gonna do is in home incarcerate him with an ankle bracelet, not let him out of the place.
Well, we can do that. If we do that, could we get a later trial date? Because that's pressing us 2 trials like that. Because we've got, if you want to go ahead.
No, it's fine if you'd rather push the trial on out.
Because I've got a witness that's living out of state. I'm gonna have some complications.
Okay, well, let's
If you're going to reduce the bond, let me know on home incarceration. and refer-
which one did you rather do?
I'll do either one.
Well, I will too.
What about me? Hey, I'm the tiebreaker vote here. Hey, me.
Well, because I've not been able to meet the young lady in the court knows who I'm talking to, I'd rather have a little bit of time. in this case.
Okay, well, let's continue the trial then.
If I want to get him out.
I know you do. And I want to make sure that the public is protected. So,
If he violates his ankle monitor, I'll be filing a motion.
okay, I'll do a $25,000. Let me do a $50,000 surety bond. There's no use going through the property stuff.
That's fine.
Do a $50,000 surety bond. Now, where's he gonna be staying?
Well, his true residence is on Pea Ridge down there where his garage is. Of course, you know where his parents live on what, Oil Fork?
Where is he gonna be staying?
He'd rather stay on Pea Ridge if he's going to be, because he can work down there out of his garage.
Okay,
That's fine. I just know.
Correct, Cody?
I don't want him on off that property there. Okay, I want an ankle bracelet on him, 24. If he leaves there for any purpose, he has to call up and get permission. Okay, no purpose leaving there. Now, if he's got a doctor's appointment, he can go to the doctor's appointment and back, and his mother can transport him.
And
Okay.
he'll be needing
Now,
to
I
meet with
want
me.
no contact whatsoever with the alleged victim.
Absolutely.
No contact.
Could we keep the 22nd date or whatever, the 21st, if you want to have a hearing on 404 day? Or you want to just wait on that?
Well, since we don't have a trial date yet,
But could we then we'll have a pre-trial and it's going to be arraigned next month, get a trial date in April?
yeah, that'll be good. Let's have he'll be arraigned, he'll be served and arraigned, and the bond will cover this additional charge, okay? And then you come back here for arraignment and setting a trial date on April the 13th. You don't want him there for negotiation?
There's no need.
Okay, April the 13th, he'll be back in court. Now, Mr. Key, I want to tell you something. You are to follow the terms of this bond. You're to stay at your property where your house is and your garage, and not get off that property. If you have to go to the doctor or something, your mother can transport you. And you call the ankle bracelet people. You understand?
Yes, sir, Your Honor.
Now, and I'm not going to ask you whether or not you've been violent on these occasions, but these charges have got my attention and have me a little reserved about whether you're a violent person or not. Now, I don't want you to comment on that, but I'm going to tell you, if you violate the terms of this bond, you'll be immediately jailed and the people could forfeit. You understand what I'm saying?
Yes, sir.
Okay, thank you very much.
Thank you. I'll be down, Cody.
Jameson Milam. Mr. Stockton? Mr. Stockton?
Yes, Your Honor.
While
Yes,
we
Your Honor.
still have Cody Key here, I guess we need, if there's some way we could get him served. I know it hadn't been processed or anything. Is there any way we can process and get him in the system today to serve him? So they won't have to go.
He'll be in jail for a couple hours.
Well, I understand that. Is there any way we can get him in the computer? Okay, and we'll go ahead and serve him now. And the bond decision on him will be that he'll be under the $50,000 surety bond in the same conditions, okay? Jameson Milam. Jameson Milam. Are you Jameson Milam?
Yes, sir.
This is 23 CR 0008. Mr. Milam, were you born in 2003?
Yes, sir.
The last four digits of your social security number, 6011.
Sir.
Okay, you're here for a pre-trial conference. What does the Commonwealth have to say?
Know that we have a resolution on this, do we, Mr.
We
Sheffield?
do, Judge, we do. We have a pretrial diversion plea for the court.
Mr. Milam, motion to file says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 23 CR 0008.
Yes, sir.
Is your judgment impaired in any way today?
What was that, Your Honor?
Is your judgment impaired? Do you know what's going on today? Are you aware of what's going on?
Yes, sir. Yes, sir.
Okay. Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have the right not to testify against yourself. No one can make you say anything. Right to speak trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. You have the right to produce evidence. Right to call witnesses in your favor. Have process issues. Compel their attendance. You have the right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that by entering a
Yes.
guilty plea today, you give up those rights. You understand that?
Yes, Your Honor.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. In the event that the recommendation decide to impose a harsher sentence, you're right to withdraw your plea of guilty and proceed to trial. Now, I'm gonna ask you a couple of questions. Have you previously been diverted in the last 5 years?
No, no, sir.
Any felony convictions in the last 10 years?
No, sir.
Okay. You understand that if you successfully complete the pretrial diversion agreement, the charges will be dismissed and you can have them expunged from your record. You understand that?
Yes, Your Honor.
You understand if you do not complete the diversion program brought before me, I'll have a pre-sentence investigation report done, sentencing you to be a convicted felon. Do you understand that?
Yes, sir.
Now, listen very carefully. What is the Commonwealth's recommendation?
Your Honor, Mr. Milam will plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years. He will plead guilty to receiving stolen property, receive a sentence of 5 years, total of 5 years, pretrial diverted for 5 years, diversions to be supervised. He's to enter and complete the Clinton County Specialty Court Program. He'll remain incarcerated until the day of his of the Specialty Court Program orientation. He agrees to forfeit the $559 in this case. All other personal property shall be returned to the victim. Defendant shall pay court costs at discretion of the court. And once he's released, he'll obtain and maintain gainful employment.
Is that what you agreed to?
Yes, Your Honor.
Okay, are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
Okay, I'm gonna accept your plea as a voluntary plea. And you said you understand your constitutional rights. You desire to allow the court to impose this judgment.
Yes, sir.
It's your signature, hold the signature up there, Mr. Shepherd. Is that your signature on there, sir?
Yes, Your
I'll
Honor.
the agreement, sign an order to drug court. As soon as you get oriented, you can be released to that. The court costs in the matter are $155, and since you're going into drug court, I'll allow you to pay those at $30 a month. The first payment 30 days from today. Okay.
Yes, Your Honor.
Okay. Thank you very much.
Thank you.
Yeah, Ryan Nally. Commonwealth versus Ryan Nally, 22 CR 0014. Are you Ryan Nally?
Sir.
Born in 1982.
Yes, Your Honor.
Last 4 digits, social security number 5190. Have you had an opportunity to look at your pre-sentence investigation report done with probation and parole?
Yes, Your Honor.
Substantially correct?
As far as I can see, yes.
Okay, Mr. Shepherd, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to complicity in burglary second degree, then it shall receive a sentence of 10 years. Upon a plea of guilty complicity to theft unlawful taking over 1,000, he shall receive 5 years. However, the two sentences shall run concurrently for a sentence of 10 years, probated for 5 years. Probation is to be supervised. What's the court cost? Court costs $155. Since you're just now getting out, I'm gonna give you an opportunity to pay that monthly, so you can pay the first payment $30. 30 days to a day and every 30 days until the 155 is paid. You still receive credit for time served. I guess the probation and parole meet with this gentleman.
Thursday, working today.
Yeah, he's probably going back out of state, Suzanne, and I need good contact information on him because he's a witness in another case.
Go see him this afternoon. The probation and parole is going to be down there to see you this afternoon before you're released. So the jail is not to release him until probation and parole comes down and interviews him today. Okay?
Sure.
Okay, thank you.
Thank
you. Wesley Rains. Commonwealth versus Wesley Rains. Do what? Commonwealth versus Wesley Rains, 22 CR 0065 0066, 21 CR 0028. Are you Wesley Rains?
Sir.
Oh, I understand that you wish to enter a plea today. Is that right?
Yes, sir.
It's a felony plea.
Yes.
A motion has been tendered that says that you wish to enter a plea. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily entered?
Yes.
Are you the same person named in indictments number 22 CR 0065 66 and 21 CR 0028?
Yes.
Is your judgment impaired today in any way?
Yeah.
Have you discussed the charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence that the Commonwealth has against you?
Yes, sir.
You believe that you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. The right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Understand that the enter guilty plea today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed by law. Prior to making the determination, I will await the pre-sentence investigation report to be done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you'll have the right to withdraw your plea and proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to indictment number 22 CR 65 for the charge of wanton endangerment first degree, the defendant shall receive a sentence of 1 year. Upon a plea of guilty to indictment number 22 CR 66 for the charge of receiving stolen property over $1,000, the defendant shall receive a sentence of 1 year. The 2 1-year sentences shall run concurrently for a total of 1 year. The defendant agrees to stipulate to the pretrial diversion revocation in Clinton indictment number 21 CR 28. Final sentencing in Clinton indictment number 21 CR 28 shall be scheduled the same day for Clinton indictment numbers 22 CR 65 and 22 CR 66. The 1-year sentence in Clinton indictment numbers 22 CR 65 and 22 CR 66 shall run consecutively with Clinton's indictment number 21 CR 28. The Commonwealth will oppose probation. The defendant shall receive credit for time served, shall pay a fine and court costs at the discretion of the court, and agrees to have any and all evidence in the above style cases disposed of in accordance with the laws of the Commonwealth of Kentucky and the holding agency.
What's the court cost? Court cost $155, payable $30. Is that what you agreed to, what you just read?
Yeah.
Okay. Well, I will order a pre-sentence investigation report under probation and parole. You realize that once you enter this plea of these felonies, they can be used against you in the future for any subsequent felonies to enhance your sentences in a persistent felony offender law. Do you understand that?
Yes, sir.
You have a copy of the agreement? Okay, that's your signature on the agreement, is that correct?
Yes, sir.
Well, accept the agreement, order PSI and have you brought back on all these cases for sentencing on April the 13th. Okay, thank you very much.
Thank you.
Alfred Silva. Alfred Silva. Okay, I'm going to appoint the Office of Public Advocacy to represent Mr. Silva. Mr. Shuffett, are you on there? There's been an affidavit filed that shows his need. You're here today for the purpose of the arraignment. Mr. Silva, you see Mr. Shuffett in the green shirt? He's
Yes, sir.
Attorney. The grand jury of Clinton County has returned an indictment charging you with rape in the first degree and stalking in the second degree. You take that back to Mr. Shuffett. Mr. Shuffett, you recognize, you acknowledge the identity of your client. Informal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Judge.
We will need to set a negotiation day up on this. On April the 7th. And the next court appearance on April the 13th, the 7th being at 1 o'clock, the 13th at 9 o'clock.
Judge, what is his bond on this?
50,000 cash, ankle bracelet, complete curfew. So you can have an opportunity to interview him, and if you want to talk Commonwealth about the bond, I'll await your all's discussion. Is that all right, Ms. Gordon Anderson?
Yes, Your Honor.
Okay, Commonwealth versus William Stearns. Commonwealth versus William Stearns. 23 CR 0009. Are you William Stearns?
Yes, sir.
Were you born in 1976? The last four digits, social 641.
Yes, sir.
Okay, we're here today for pre-trial conference. What do you have, Ms. Gordon Anderson?
We have a felony plea, Your Honor.
Okay. Mr. Stearns, a motion has been tendered that says you wish to enter plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Okay. Are you the same person named in indictment number 23 CR 0009?
Yes, sir.
Have you discussed this matter with your attorney, reviewed the evidence, you feel like you're fully informed about your case?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
You understand that you have certain rights in the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right, you have a right not to testify against yourself. No one can make you say anything, or right to speak, trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charges against you. By entering this plea of guilty, you give up those rights. Do you understand that?
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting the recommendation, I will enter have a pre-sentence investigation report done by probation and parole. In the event I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Mr. Gordon Anderson, what is the recommendation of the Commonwealth?
Yes, Your Honor. Upon a plea of guilty to failure to comply with sex offender registry first offense, the defendant shall receive a sentence of 1 year probated for 2 years. Probation is to be supervised. The defendant shall receive credit for time served and shall be released at sentencing. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained.
Okay. We'll order a pre-sentence investigation.
Judge, it was actually 1 year probated for 1 year. The paperwork that got sent out does say 2 years. So I understand why she said that. But after we got the paperwork, I communicated with Mr. Stockton and he confirmed that it was 1 year. I should have had him change. I've already changed it and I'm going to have him initial it.
That's correct.
That it was actually probated for 1 year.
Okay. Is that what you agreed to, sir?
Yes, sir.
Okay, are you entering a guilty plea because you are guilty?
Yes, sir.
Okay, now, knowing your constitutional rights is still your desire to give up those rights, allow me to set the punishment within the range permitted by law.
Yes, sir.
Mr. Shepherd, will you hold up the document and show the signature? Is that your signature on this thing?
Yes, sir.
Okay, I'll accept it. Order the pre-sentence investigation report to be done by probation and parole. Now, let me ask you something, Mr. Stockton.
Yes.
This requires just a regular pre-sentence investigation report, or will it have to be a sex?
My understanding on these, he just has a regular PSI.
Okay, I just want to make sure. Okay, because those others take a long time right now. Okay, well, we'll see you here then.
And
on
Judge,
April.
I did want to inquire of the court. His father is very sick and is currently in the hospital at Clinton County. I communicated with this as well with Mr. Stockton yesterday. And I was going, since he is getting probated and he is currently in compliance with the registration, which I think was the motivation behind the Commonwealth's offer. I would ask the court to consider amending his bond for him to be released pending sentencing.
Well, I'm not going to do that, but if his father has a near death situation or something like that, I will consider furloughing him out to go visit his father at the hospital out of humanitarian considerations. So if that happens, Mr. Shepherd, you need to contact some agreed order. And Mr. Stockton, I do not want to deny anyone the opportunity to be there if his father is in a near death situation. Okay, thank you very much. Court costs are how much?
$155.
$155, allow that to be paid $30 a month, first payment $30 at 30 days after release. Okay, is there any other matter on the docket?
We have Sydney Foster and Jeremy Robertson.
Are we ready on Sydney Foster?
And
Is there anything- nobody else?
the rest of those up there to Melissa, and there are some things the judge needs to sign too.
Sydney Foster, Sydney Foster,
He was on it in person. He's done the rest of us.
yeah, called Sydney Foster. Are you Sydney Foster?
Yes, sir.
This is 21 CR 00100. Were you born in 1972?
Yes, sir.
4 digits, social security number 8738.
Yes, sir.
What does the Commonwealth have to say in this case here?
Your Honor, we've been attempting to negotiate a plea for 2 months. And then I've got notice that Mr. Foster has new arrest, so I withdrew all offers in this case. And I'd like to set a trial on the possession case and go ahead and try that. And then I'll see what the grand jury does on the new case.
Okay.
Judge, it would be my request, if we could pass this for 1 month before setting the trial date, whether it be me or another attorney, we will know.
I
what-
think since we might be having change of counsel, that might be a good idea.
That's fine.
We'll
We'll just
we'll
put it,
have the new council present for negotiation day on April the 7th and have the person up to steam on this thing, and then have a pretrial on April the 13th. And if there's not a plea on that day, Mr. Stockton will set a jury trial, okay?
well, Your Honor, I'd also ask that his bond be revoked on this case because recently he was arrested. He was alleged to have been shooting at people at a apartment here in town. So I'd ask he be held with a high bond until,
I'll revoke his bond and hold him without bond until that time. Okay. Okay. Yeah. Okay, now, we have one other case, do we? What is that? Jeremy Albertson. Commonwealth versus Jerry Albertson. 22 CR 0057 58 59 60 and 22 CR 0079. Are you Jerry Albertson?
Good.
Were you born in 2004?
Yes, sir.
Last four digits, social security number 6324.
It's gonna take a while to get
I
through.
understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? Are you the same person named in indictment 22 CR 57 58 59 60 22 CR 0079? Is that you?
Yes, sir.
Is your judgment impaired today in any way?
What is it?
Is your judgment impaired today in any way?
Thanks, Ray. Yeah, no, I think.
You know what's going on? You know what's going on here?
Yes, sir.
Have you had plenty of time to review the evidence of this case, and are you satisfied with your attorney's advice?
Yes, sir, I am.
You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Did you understand that by entering a guilty plea today, you give up all those rights? You understand that?
Yes, sir, I do.
Consider the Commonwealth's recommendation that I may apply any range of sentence allowed by law. I do not have to accept it. Prior to accepting the recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to indictment number 22 CR 79 for the charge of burglary third degree, the defendant shall receive a sentence of 5 years, receiving stolen property, a sentence of 5 years, and criminal mischief first degree, a sentence of 5 years. The 3 5-year sentences shall run concurrently for a total of 5 years. Upon a plea of guilty to indictment number 22 CR 61 for the charge of receiving stolen property, the defendant shall receive a sentence of 5 years. For tampering with physical evidence, a sentence of 5 years, a criminal mischief first degree.
I don't have 61 on my docket. I have 57, 58, 59, and 60, and 79. You just get left off. I just want to make sure. 61 is correct? Okay, you may proceed.
So upon a plea of guilty to indictment number 22 CR 61, the charge of receiving stolen property, the defendant shall receive a sentence of 5 years. Tampering with physical evidence, a sentence of 5 years. Criminal mischief first degree, a sentence of 5 years, and arson second degree, the defendant shall receive a sentence of 15 years. The 3 5-year sentences and the 15-year sentence shall run concurrently for a total of 15 years. Under indictment number 22 CR 61, and once released from incarceration, the defendant shall pay restitution in the amount of $3,800 to the Clinton Circuit Court Clerk and be dispersed in accordance with said forfeiture order. Upon a plea of guilty to indictment number 22 CR 59 for the charge of receiving stolen property, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to indictment number 22 CR 57 for the charge of receiving stolen property, the defendant shall receive a sentence of 5 years, and possession of a controlled substance first degree, a sentence of 3 years. The 5-year sentence and the 3-year sentence shall run concurrently for 5 years. Upon a plea of guilty to indictment number 22 CR 58 for the charge of receiving stolen property, the defendant shall receive a sentence of 5 years. The 5-year sentences in indictment numbers 22 CR 79, 22 CR 59, 22 CR 57, and 22 CR 58 shall run concurrently with indictment number 22 CR 61 for a total of 15 years to serve. The Commonwealth will oppose probation and shock probation. The defendant shall receive credit for time served, and the defendant shall pay a fine and court costs at the discretion of the court. The defendant agrees to have any and all evidence in the above style cases disposed of in accordance with the laws of the Commonwealth of Kentucky and the holding agency.
Is that what you agreed to, sir?
Yes, sir.
You pleaded guilty because you did commit the acts charged in the indictment as amended.
Yes, sir.
Know your constitutional rights is still your desire to allow the court to set your sentence within the bounds of law.
What is it?
You understand that after ending this guilty plea, any future convictions you might have of felons could be enhanced in a persistent felony offender law. Do you understand that?
Yes, sir.
Okay, do you have the document there? Is that your signature on there?
Yes, sir, it is.
I'll accept a plea order, pre-sentence investigation report to be done by probation and parole schedule sentencing for the 13th. Considering the length of the sentence, I will be waiving court costs.
Thank you.
In the thing. Okay, so we'll see you on April the 13th for sentence. Is there any other matter to come before the Clinton Circuit Court of Criminal? Mr. Stockton, Ms. Gordon Anderson, y'all have anything else? Okay, so y'all send this till 1 o'clock. Is that right? Thank you.
Judge, we have an agreed order on this case.
Carter versus Carter.
Your Honor, in this case, Mr. Carter is ordered to pay $316 a month on current and $146 on arrears. We're asking that $900 be paid by April the 12th of this year.
Okay. Cooksey versus Cooksey.
Your Honor, in this case, Mr. Cooksey is ordered to pay $208 a month on current and $50 on arrears. And we're asking that $1,000 be paid by April 12th.
Judge, I'm sorry, they just said a second part of the home.
Oh, okay. He must have just popped up.
Carter.
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 You what?
Oh, yeah.
No, Rick. We previously called, we went on the record, we previously called McWhorter, we had a versus Arnold. We want to see us here, so we had an agreed order there. Now we're gonna call Carter versus Carter. You, Mr. Carter? What do you got here?
Judge, Mr. Carter is ordered to pay $316 a month on current and $146 on arrears. The balance as of today is $1,264, and we're asking if he could pay $900 by April the 12th.
Could you tell me why it's that much?
There's been no payments made according to the record.
I was signing an agreement 2 months ago that there wasn't no child support though. In my divorce agreement.
Is this the?
Well, I don't think, can you sign an agreement that there's not any child support?
Yeah, I'm
I
not
mean,
aware
yeah,
of it.
I signed.
I don't think it's legal to sign an agreement. There's no child support.
Obviously, we wasn't involved in the divorce. I'm not aware of that, so.
Are you receiving any benefits for the children?
No.
So they don't have any K-chip or anything else? And why was it that there was agreement that there would be no child support?
He was supposed to provide everything that they needed.
You need to come up here. Raise your right hand, please. We'll swear the testimony about to give us truth, oath with nothing but truth. Go ahead.
He was supposed to provide everything that they needed school supply wise.
You have to speak up.
He was supposed to provide everything that they needed school supplies wise and anything that they needed.
Has he been doing that?
No.
Well. I'm gonna just say that agreement is void. And then if there's a time period that he was, what's your side of the story? Were you supposed to provide things?
Do what?
Were you supposed to provide things for him?
Yes.
Why haven't you done that?
I mean, everything just didn't meet her standards. I mean, I did go and get them all stuff. I did.
Well, that's the reason that we have the child support orders to hold down the stuff. What do you want to do about the time period where this was supposedly in place? I'm just gonna order him to pay. I'm just gonna order him to pay the child support, but I'm not gonna order him to pay the $900 just quickly when he thought that he wasn't gonna do it. I wanna add $100 a month to what he's supposed to pay.
Okay,
And how much would that be?
that'd be $416.
Okay, I'm gonna give you a break on that, so you don't have to come up with that. You need, the best way for you to do this thing is to pay this child support. If you don't feel like you've got any obligation to do any more for your children than that, that's up to you. Okay, but you can't do very much for $400 a month for children.
Yeah, I understand.
So, but in order to protect you, you need to pay that 400 a month. They can't be a doubt about that. The first payment will be due on when?
April 12th.
Okay. Okay, so you got an amount now and you can pay it, and that 900 that they're gonna do will be spread out over a period of time, okay?
All right, so that other thing's just void
It
then?
is board, yeah.
Okay, so,
Okay, no problem. What is this?
that means I can, that means like all the tax rights and everything. See, I give up all my tax rights and everything to her, whatever.
Well, let me tell you about your tax rights. You're not paying 50% of what it costs to raise those children right now at $400 a month, so you don't really have any tax rights. Do you work somewhere? Where do you work at?
She goes SSI.
Okay, well, here's the thing about it is, if he can get earned income credit or whatever, you'd be better for both of you to go to the county attorney's office and talk to see whose benefit it would be. You agree with that? So both of you need a meeting over there. Where do you work at?
I've been doing carpentry work.
Well, that's good. You make good money doing carpentry work, but what you gotta do is figure out, are you planning on going to work? Do what? Okay, are you able-bodied or you have a disability? Okay. You're on social security or just SSI? So you didn't have enough quarters in this to qualify for social security. Well, you can talk about that privately, the ladies, at the county attorney's office, and see which would be the benefit for the children, okay? Thank you. We'll need another order on this.
Yeah.
Here you go. So here's the other. Cooksey versus Cooksey.
Judge, in this one, Mr. Cooks, he's ordered to pay 208. Oh, it's
Already said.
oh, it's not.
Daniel versus Daniel.
Judge, in this case, the non-custodial parents ordered to pay 300 a month on arrears. It's an arrears case and asking to pay 700 by April the 12th.
Somebody needs to add in there that, in that other case that we just did, that it appears that, although the parties attempted to sign something where he would avoid paying any child support, he did not comply with it, so it was ruled to be void ab initio. Did I get Daniel versus Daniel?
Yes, sir.
Guffey versus Guffey.
Your Honor, in this case, Mr. Guffey's ordered to pay $660 a month on current, $132 on arrears, and asking that he pay $1,500 by April the 12th.
Cabinet versus Mendoza.
We're gonna renotice that.
Cabinet versus Purdue.
We have an agreed order, Judge.
Thacker versus Thacker.
Judge, there's an agreed order in that.
Thurman versus Thurman.
Your Honor, this is an arrears only case, and we're asking that Mr. Thurman pay $500 by April the 12th.
Does he have any property or anything? He owes $10,000.
Not to our knowledge, not any real property, personal property, probably only, but not any real property.
Doesn't have a job.
No. Probably a cash job. Yeah.
We had one over there that, okay, that concludes child support. Let's go off the record just for a second. We had somebody